My name is Ashley Kearns. I am the Director of South Carolina Community Management for Cedar Management Group. Nicole DeRiso, also with Cedar Management, is the Director for North Carolina and Tennessee. Together, Nicole and I oversee 8 area managers throughout the states and over 60 community managers. That is throughout the Carolinas and Tennessee. Finally, Ken Love, originally from Fort Bragg, North Carolina. Ken graduated magna cum laude from North Carolina Central University in 2003 with a Bachelor of Arts in Political Science and Psychology. He obtained his law degree from the University of Cincinnati College of Law in 2006. He's also an adjunct professor of law and in the paralegal technology program, at Central Piedmont Community College, in addition to being licensed to practice law in the state courts of North Carolina. Ken is also licensed to practice in the federal courts of the Middle Western Districts of North Carolina, the Fourth Circuit Court of Appeals, and the United States Supreme Court. Ken is both certified as a specialist in consumer bankruptcy law and is rated as a member of the super lawyers list. So without further ado, I'm going to turn it over to Ken.
Hello, everyone. Hope you are well today. As Ashley said, my name is Ken Love. I am going to start the presentation today, which we're going to be talking about serving on a board basics. Some of this information may be repetitive for some people. It might just be a refresher. Hopefully there'll be a good bit that you will learn from it that may be helpful from you. As Ashley said, the way I like to do presentations is I really do ask that if you have questions, feel free to ask them during the presentation. I feel it's better than attempting to do it at the end where it may be forgotten or out of context. So as we go through this, just feel free to jump in and let's talk. So today we're going to kind of cover the basics of HOA governance. So where are you going to get the laws and the rules and what governs what HOAs can and can't do. Requirements for board participation. So when you join a board, what is expected of you? What are you required to do? We'll talk about that a bit. And then some of the best practices that you can participate in and some items that you should avoid. Over the last couple of years, we've seen a lot of things happen, and hopefully today we could talk about some of those things that might help you either your board do a little better or avoid some of the things that might get some people in trouble. So first thing to talk about, what are we talking about today? So HOAs, COAs, POAs, NOAs, you know, there's a million different names, and I hear a lot of people use different names and different communities are set up different ways by their developers. Ultimately, we're talking about the same thing. A group of people who live in an area that have a set of rules that are designed to guide how the community works together. Obviously, some communities have more rules, some communities have less. And then even more obviously, HOAs get a bad rap a lot of times in terms of being power hungry or overbearing. And I would say HOAs are just as good as the people who are in them. For lack of a better word, some people might say it's a necessary evil, but without HOAs, you know, chaos reigns a lot of times in these communities. That's why they were created. I hear someone, I don't know if someone had a question. Okay, if not, but essentially, at least in North Carolina and South Carolina to a bit, and I apologize if there are any Tennessee folks. I'm not licensed in Tennessee. A lot of what we're going to talk about is basically universal. There was sometimes where I'll talk about the law and I'll make sure to differentiate between North Carolina and South Carolina. I'm not well versed in Tennessee law, so I will apologize to those folks. But for anything where I don't cite a specific law, the items that we're talking about today are pretty universal. And so essentially, the only two associations where you will see some difference are going to be primarily condominium association and homeowner associations. Now, they could be named different things. I've seen property owner associations, neighborhood associations. I've seen other different landowners associations, but essentially a condo association is essentially just a group of people who lived in condos that essentially should be stacked on top of each other, whether it's 2 floors, 3 floors, maybe more. There are certain requirements there because obviously we're dealing with a building with nooks and crannies that the HOA is responsible for in between each of those units. Whereas homeowner associations are typically going to be single family homes, townhomes, any of those types of items where the homeowner is responsible for primarily most of the unit and what's happening around it. But the first thing I want everyone to understand, and this is the same law in all 3 states, that all HOAs, condo associations, what have you, are considered nonprofit corporations. And because of that, they are regulated by the Nonprofit Corporation Acts in your relative states. So in North Carolina, the Nonprofit Corporation Act is in Chapter 55A. So if you go to Chapter 55A, you would be able to read any of the regulations that cover all nonprofit corporations. This could be HOAs, United Way, the American Red Cross, any group that calls themselves a nonprofit in North Carolina would be regulated there. South Carolina is regulated by Title 33 of the South Carolina Code of Laws. And I will tell you the two statutory schemes are desperately close together. They're really word for word the same thing with little minor differences there, here or there. And unfortunately, I don't know the site to Tennessee, so unfortunately I can't give you that, but there is a nonprofit corporation statute there. Now, typically, as HOAs are very specialized nonprofit organizations, there are different acts that cover them. Now, we'll tell you this, in South Carolina, there is currently no real statutory scheme for HOAs. Back in 2008, the legislature in South Carolina passed rules that required HOAs to make sure all of their governing documents were recorded. But outside of recording the documents and making sure your declaration, bylaws, rules, and all those good things are actually in the public record with your county register of deeds, there are no regulations. So every rule and law that a South Carolina HOA or condo association will follow will be based on their declaration. Whereas North Carolina has a pretty thorough scheme of regulations. So in North Carolina, there are 3 main chapters of the general statutes that cover the various associations. So starting with condos, there are two regulations. So one is going to be Chapter 47C, which this is for any condo association in which it was incorporated and or created after October of 1986. So if your condo was created after that point, you follow 47C. If it was before 1986, then you would follow Chapter 47A. However, there are certain provisions of Chapter 47C that will be applicable, and we'll talk about some of those a little bit today. But typically, you would follow the relative chapter based on the age of the condo. For homeowners associations, anything that's not considered a stacked condo in North Carolina, you would follow Chapter 47F. And single-family homes, townhomes, anything not considered as a stacked condominium, they follow Chapter 47F, but these are for anything created after January 1st, 1999. Again, some provisions of this will apply to some of the older communities, but most likely, any regulations you'll follow will be there or in your declaration. So let's talk about the priority of laws, because obviously there will be times where you will run into an issue and there will be 2 different sets of laws or rules you will look at and say, which one do I follow? And this is pretty much the hierarchy you should follow, no matter what your state is, except for obviously in South Carolina, you won't have step 2 and 3. So first is any relative federal law you will follow first. So there will be certain laws such as the Fair Housing Act. There are certain regulations that protect the American flag. So some HOAs may have rules that you can't have flags, but you specifically can't ban the flying of the American flag. Satellite dishes, there are certain protections for those, and solar panels. There is a regulation in North Carolina that deals with solar panels. There was a regulation that was going to limit how HOAs dealt with solar panels in South Carolina. That bill stalled in the legislature earlier this year and has not come out of committee. So as of right now, excuse me, earlier last year, and has not come out of committee. So as of right now, there are no regulations in South Carolina that force solar panels, where North Carolina does have them.
Yeah, excuse me, Mr. Love.
Yes.
You mentioned solar panels for North Carolina. Is there a chapter or somewhere that talks about that?
Yes, chapter 22B-20 of the general statutes. It's in an extremely weird place. But if you were to go to chapter, if you Google North Carolina general statutes, and then you go to chapter 22B-20, that will talk about the solar panels. And let's make note of that, because I want to get through the presentation, but that's like a hotbed topic right now. So as we get to the end, we have a little bit of time. We'll definitely talk about that a little bit more too. That's a good question. But yeah, so look at any relative federal, state law, and if there's one law that says, hey, HOAs can't do this, that's it, they win. After that, at least in North Carolina, you would look at whatever your relative chapter of 47 is, whether it's A, C, or F. Then chapter 55A or title 33 in South Carolina. Then you will look at any local ordinances. And so there may be times that your city, county may pass rules. Typically, your declarations will control your community. The only time a local ordinance you'll have to follow is if it conflicts with your declaration. So say you have a regulation that deals with setbacks and how you deal with fences. The fence has to be this close to the edge of the property or at the back of the property. If the county has an ordinance that either expands upon that or limits it a little bit, your declaration is fine. Now, if you have an ordinance that says, nope, you can't pass that rule, then the ordinance will control over your declaration. But otherwise, you would follow your declaration, and we're going to talk a little bit more about what these documents are, the Declaration of Covenant, Conditions, and Restrictions, and that's pretty universal across the country. That's a term that's used in California, Texas, wherever you go. That's pretty consistent. Articles of Incorporation we'll talk about, and the bylaws. So let's get into those. So starting off with the Declaration of Covenants, Conditions, and Restrictions, think of this as the Constitution for your community. So these are the rules that were put in place before just about anybody moved into the community. And then they may be amended from time to time following the rules of the declaration. But these are typically the rules that must be followed or should be enforced by the board of directors. This is how big your house must be, can't be smaller than this, must keep your lawn in good order and maintenance, can't have vicious animals, whatever those types of rules are. So think of these as the substance of your rule. These are the rules to say what you can and can't do in your community. And typically, unless they're overridden by a superior law, so as you heard, solar panels was highlighted again, there are certain rules in North Carolina that says you can't ban solar panels, you could just regulate them in some fashion. In those cases, if you have a declaration provision that says no solar panels, that's been overridden. And now you're stuck with, now let's talk about how we regulate them, where do we put them, how do we deal with them? But otherwise, the declaration are the rules, the supreme law of your association. And the biggest thing that I will stress is the board at all times should act in a manner that is both consistent and equitable in its enforcement of these provisions. A lot of times, the biggest headaches that I see boards go through are when people claim, they told me I couldn't have this, but this person has it, or they're enforcing this against these 8 people. They don't enforce it against these 6 people. As long as you stay as consistent as possible and as equitable as possible, we're all still human beings. So we read the black letter of the law, but sometimes they're such as with the Fair Housing Act, there might be sometimes we have to bend a little bit, but the more consistent you stay, the better. Whenever I find boards who kind of make too many exceptions or well, let's let him do this, that's when you run afoul. And we're going to talk about this later on in a later section. You don't want to see yourself in a position where you help someone, because I've seen it too many times get thrown back in that board's face when that person wants to come after them. So the declaration, remember, that's going to be your constitution. So if you want to know what am I allowed to do, not allowed to do in this association, the first place you look is there. Next, we have the Articles of Incorporation. Again, this is consistent in all 3 states. The Articles of Incorporation is the document that was recorded with the Secretary of State of your relative state. And this is what creates all entities. So if someone wants to start an LLC, they file a document similar to this. And when Walmart incorporated themselves, they have Articles of Incorporation. And what this will do is essentially just create the organization and announce it to the world. So if I wanted to know what HOAs there are in North Carolina, I can go to the Secretary of State's website, look up names, and determine where all these HOAs are. So I want to name my HOA Woodcrest. I can go look and see, oh, there's already a Woodcrest in North Carolina, or there's already 6 in different places, or whatever it may be. And I could be aware of that. And that has happened, especially in the Charlotte region, where there have been a lot of, there's actually several communities in the Charlotte, Cabarrus area, where you have these massive sprawling communities where half of it's in Mech and half of it's in Cabarrus, and they actually have separate names because a name appeared in one county and not the other. So they decided to split the names up for whatever reason. A lot of weird things happen with these developers. Now, most are very basic, and we'll just say this is the name of the HOA, this is what they want to do, we're a homeowners association, and that's basically it. Some Articles of Incorporation will also have some rules in it, and so whenever evaluating these communities, it is still important to be aware, do my Articles of Incorporation have any rules in them or not? Because they still need to be followed too. Now, they are subordinate to the declaration. So if there's a rule in there and a declaration says something different, the declaration controls. But if there's a rule in there and the declaration is completely silent, then the Articles of Incorporation rule still applies. I had a community recently we were looking up, and there was no special assessment language in the declaration. It was in the Articles of Incorporation. So we had to follow the rules in the Article of Incorporation in terms of what percentage vote needed to be obtained to pass the special assessment. So make sure you're not just overlooking the Articles of Incorporation, and you should have a copy of it somewhere in the records for the board. If you go to the Secretary of State's website, they're all available. If I know your property manager in Cedar has them, but just in case you need to get a copy for yourself and couldn't get to Cedar quickly, you could go to the relative states' websites and pull them as well.
Thanks, Ken. We do have a question. James Harrell?
Sure.
Yes, and I hope I'm not getting off topic, because and I understand between the Article Corporation and CCNRs, but my main question, because my mind is on it, I don't know if I don't ask now whether or not we're going to get away from it, or if this is the best time to ask. But if you have a violator, even after the hearing takes place, the best way to deal, what is the best way to deal with violators even after you had a hearing with them? It was my question. Is my question.
I can deal with that now because I don't think I addressed that so much. And folks will pick up after Articles of Incorporation, but violators. So we have someone in the community that's consistently breaking a rule. The board has sent out a warning. They've held a hearing. And sir, I would suspect you're probably finding the person right now.
Actually, that would follow, but in a real scenario case, I have not gotten to that. We have not gotten to that yet. We just ready to do a hearing, but this person is so non-compliant. I just want to be prepared going into the hearing so I can know what can we demand.
Okay,
During the hearing.
are you in North Carolina or South Carolina?
North Carolina.
Okay, got you. So in North Carolina, and this tracks is I'll explain the only difference in South Carolina. North Carolina, so my suggestion is whenever you have a violator, and I'll touch upon this a little bit at the end of the presentation, but but you want to be as human as possible, because I will say there are a lot of people that you sit down a notice to them and they didn't realize or didn't pay attention to something with a violation and they fix it. Sometimes they do. We've had a lot of, I would imagine Ashley and Nicole could tell you, they've had many of their community managers report, we sent out notices, they got fixed within a week or whatever, close the file. So that's the first place you start. I would say, but I think we all know we have those people in our communities that are just going to be non-compliant no matter what, or just going to be onery just to be onery or whatever it may be. And at some point, again, going back to the consistent and fair enforcement of the declarations, at some point you got to get aggressive. So what happens is in North Carolina, you send out the warnings, you have the hearing. Once you have the hearing, you have to give them 5 days to become compliant. So, and I want to make this is a good point because I didn't really discuss this. So I'm glad for your question. Whenever you have these hearings, these are not law and order, folks. These are not court cases where you hire someone to be a judge, you put on evidence and all that. The board already knows what they believe they know. We believe there's a violation. We've walked the neighborhood. Our property managers walk the neighborhood. We know what we see with our eyes or what's going on. And so all you're doing at the hearing is giving this person a chance to explain whatever their position is. Give me 10 more days, I'll have it fixed. Or I'm not compliant, so I can do whatever I want to do with my property. And and somewhere in between. At that point, you give them time to speak. If the board has questions, ask a few questions. If the person has questions for the board, I would say, limit it to friendly questions. This should not be like a 20 or 30-minute exercise. Most of these hearings should be 5-10 minutes tops. After the hearing, the board should deliberate, determine, oh, do we still prosecute this as a violation, or do we say, nope, no, we understand what's going on. And I've actually been a part of hearings like that before. I had someone running an Airbnb in a community that explicitly didn't allow it. He was a little bit older and apparently senility had set in. The son came to the hearing and said, I've shut down Airbnb. We had 2 more guests that need to stay because they already paid their money. After that, we're done. He was done. Everybody was happy. Now, let's assume you have the guys that are just still going to either not show up or going to still stay in non-compliance. If that happens, North Carolina, you got to give them 5 days. After that 5th day, you can immediately hit them with a fine, and then you can fine up to $100 for every day that violation stands. Now, from there, you should work with, I know some of the communities that are on here are communities that work with my office, and I understand some of these communities obviously work with other lawyers' offices. You should work closely with your property manager and whoever your attorney that you've selected for your community is, to make sure you're on the same page that at some point we have to start moving on these, whether that's putting a lien on the property, foreclosing, or whatever it may be. And I will go on record right now, folks, I work for an HOA firm. I hate the foreclosures with a deep passion. I don't like them. But at the end of the day, they are, I said it earlier about something else, but they're a necessary evil because sometimes they do scare people into compliance very quickly. You hate to have to get to that point, whether it's putting a lien on or it's foreclosing. But I would say the biggest thing is fines, because those fines add up. But if you don't do anything with the fines, we have a couple communities in our office that refuse to go to the lien foreclosure process. And once people in your community realize that, then you've completely lost all enforcement power. And they'll do whatever. So I don't know if that answers your question. The biggest thing is go to the hearing, hold the hearing. If you decide it's still a violation, start fining as soon as possible. Keep those fines adding up. And then if they're not compliant, you have to take some action to show that you're serious. The letter from the law office and that lien, I'll tell you, in our office, I don't like the foreclosures, and we actually don't actually complete foreclosures that much, because most people either get into compliance, pay their dues or whatever it is before it gets too far in the process. So that's one good thing. Now, the only difference I would say in South Carolina, because there's not a statute that covers this, is whatever your process is in your declaration. So your declaration should have a process that says, to enforce violations, here are the steps we need to follow. However, I've seen several declarations in South Carolina that do not have a process. It is my strong recommendation, just based on the deep-seated principles of due process we have in this country. I would still recommend a quick warning letter goes out, a hearing letter goes out, and then you have a result of hearing letter. So what that means is give them some reasonable warning. Hey, you leave your trash cans out all day, every day, they need to get put up. If they don't comply, hold a hearing. After you have the hearing, you have to send them some kind of notice that says, here's what we found, the result of hearing letter. Then after that, you can fine based on whatever your declaration says you can fine. North Carolina has a limit, South Carolina does not. I would obviously say be reasonable. I don't think the courts would enforce like $1,000 a day fine for trash cans or something like that. But hopefully your declaration gives you some guidance as to what your limitations for fining are. So, sir, I hope that answered your question, at least relatively.
Thank you. I appreciate that.
Okay.
It helps a lot.
Good. Okay.
And
Yes,
we
ma'am.
may have opened up a bag here.
Well,
We have a
let's go
couple
ahead and
more
deal with it.
questions
Yeah.
in relation to this. In North Carolina, is there a minimum amount of fines due before you can start the lien against the property owner?
Good question. No, I would say this. My office, our general rule of thumb is $500. We would like to see $500 before we start, because eventually, obviously, when it comes to our office, we're going to start adding attorney fees and the lien fees and court fees will eventually get added to it. So it just, in good conscience, I don't like to have a $25 bill on my lap, and then we start adding in, and all of a sudden, a $25 becomes $1,025. But I will say this. We have our general kind of, here's our rule, but then every community we have is a little different and every situation is a little different. So I told you I hate the foreclosures. I personally handled a handful of them myself because they were that egregious that I was like, no, we got to deal with this. So there's not a minimum, and I've actually seen someone foreclose for $25. So you can move pretty quickly to it. I would say personally, though, you want to be kind of reasonable. So I would say wait till you got a couple $100. But again, if it's a violation, you could charge $100 a day. You can hit $500 in less than a week.
Okay. And what if the board does not address any violations?
Good question. And I actually talk about this later on, so I'm glad you asked it. If you are, and I'll just be honest with you, if you're going to be on the board, and your board is not addressing any violations, you have basically just destroyed the concept of having an HOA in the first place.
Okay.
The rules need to be followed. That's just plain and simple. If you get into a community and let's say you hear everybody hates a rule, there's a process where you can amend the declaration and get rid of some rules, get rid of all of them, whatever you want to do, but you got to follow that process. Whenever a board decides they're not going to enforce certain violations or any violations, something will eventually come up. And the board will then say, oh no, this is egregious. We have to stop this. And then once you do that, that person is going to run to court and say, they're violating me for this. Now let me show you the 100 violations they're ignoring and they publicly said they're going to ignore. A court will shoot that down every day of the week. Well, we'll shoot down the violation because they'll basically say you have made your declaration defunct. And so trying to enforce them in the future will be near impossible. So once you go down that road, you may not be able to come back. So I caution boards against even deciding we don't like this violate or this. So a declaration, like the declaration in my community has a rule that says no sheds. And I know most of the people, and it's still a newer community, we're still building up. And I know most of the people that have moved in are like, that's a stupid rule. Well, then once we take control of the HOA, we need to change the rule if we don't like it. We can't just ignore it. We have to change the rule. So yes, if you have a board that is essentially not enforcing rules, that needs to change like yesterday, because
Ken,
something will happen down the road. Someone, I have an HOA where someone started a car wash. And you can imagine how, like in their front yard, it's literally a car wash. And you can imagine how disruptive that could be to the community. Or I had a nightclub in one of our communities. I mean, a legit. I serve alcohol. I charge entry fees. My house is turned into a nightclub, and we party till 4 o'clock in the morning. And so you will now be in a position where you won't be able to stop that when it comes down the road, because you're basically sending the message, we have no rules.
Ken, I have a question. If a homeowner is in bankruptcy, are you allowed to serve them with violations?
Okay, very good question. So as we know, bankruptcy is a whole nother ball of wax and is very scary. I will tell you this, and I have to be careful how I say this. You want to make sure whatever HOA attorney you're working with has a holistic view and can understand a lot of these different concepts so you can get the advice you need. I would say this, when it comes to bankruptcy, I would be very careful in trying to give you very generic advice that says this is the way it's going to work for every single bankruptcy. But typically speaking, when it comes to bankruptcy, once the person files, anything that happens with the HOA, because there's a special carve out for HOAs in the bankruptcy code that happens after they file, you can still deal with. So you can still violate the person and fine them. You cannot put a lien on the property or actually go through foreclosure until you get what's called relief from stay. And that's where you get permission from the bankruptcy court to proceed, which if the person's violating the rules or not taking care of what they need to take care of, bankruptcy courts do grant that. So you want to make sure if you need that, your attorney is prepared to go through that process. But yes, you can fine, you can cut off privileges, you can do everything up to attempting to put a lien or foreclose on the property in bankruptcy until you get permission, which can be sought and granted.
Thank you.
I
Ken.
have a question. Okay.
Go ahead, Ms. Patrick.
Oh, okay. I heard you say that if you didn't enforce these rules, then you kind of null and void. Okay, I'm just new to our board, and they're talking about something that happened, a violation that happened when we had we didn't have Cedar management. We had someone else, and that person, that violator, had responded and said, you know, I was told by the previous management firm that to go to the state, and I followed those rules. Okay, so the bottom line is they haven't done anything all this time. And I suggested, we've already lost ground. Do we just grandfather that in? Because you can't enforce something a year later that you didn't.
Well, actually, yes. So in both North Carolina and South Carolina, again, my apologies to Tennessee folks that may be on, there's what's called a 6-year statute of limitations. And what that essentially means is once a violation exists for 6 years, you can't enforce it after that point. But if you're at 5 years, someone puts up a chain link fence and puts their washing machine in the front yard and starts putting the couch in the front yard and says, we're going to be hillbillies in this community. Hopefully I didn't offend anybody with that. But essentially, if you let it sit there for 6 years, then you've got the guy with the couch and the lawn and all the junk that's going to build up in the front yard. Can't do anything about that after that point. However, if you get to it before the 6 years, you can absolutely enforce it. Now, here's the biggest thing to remember, folks. And this comes up a lot, especially like with ARC requests and maybe the board didn't respond quickly enough or whatever. The declarations are recorded in every state. The reason that is important is that every homeowner is on what's called constructive notice of the rules. So if you have a declaration, I'm making something up, that says no portable basketball hoops in your yard, and a person has a portable basketball hoop, and you come up to them and say, no, you can't have that, they're on notice that that's the rule. They can't say, oh, but your property manager said I could have it, the declarant said I could have it, this person said I could have it. That's irrelevant because there's a recorded document that says no, plain and simple. So and I've had these situations before where a board wasn't doing something, next board comes in and says, hey, we need to clean this up. I would say, yes, get in there and clean it up and I'm going to use this word several times during this presentation, efficiently. I don't want to say quickly because obviously you don't want to go in breakneck speed and shock the community, because then you'll have everybody against you, but you want to move efficiently where you deal with the problems, but you deal with it in a humane way, where it's, hey, we know this last board didn't do anything about it, but we really got to enforce these things and we have to deal with it. And again, if the whole community comes up to you and says, we don't like this rule, then the community needs to get together and change the rule, plain and simple. There's a process for it. It can be done.
If we
Thank
could take
you.
Mr. Harrell's question and then move back on to the presentation. James Harrell?
Yes, so once you put a lien, and can that be escalated to a foreclosure or vice versa?
Yes, the lien is what you need to have before you can go to foreclosure in all states. So what
Okay.
would happen is the process is you go through collection. Every office does it a little differently at different speeds. Cedar plays a part in it where they step in and do something first, and then it goes to the law office. We have collection procedures. We place a lien, and then at some point, once the board says yes, that's when you could go to foreclosure. And hopefully the person pays or solve the problem, and you don't actually have to sell a house.
Thanks.
But yes, lien and then foreclosure. So getting a little bit back on track, folks, and the questions are good. I'm gonna move through to try and catch us back up, but please, the questions are helpful. So remember, declaration, we have the articles of incorporation, and then finally we have the bylaws. One of my very minor pet peeves, only because in the law, language is very important. If you go to court and you use the wrong word, it can mean something totally different to a judge and a jury. So it's important to have the language kind of laid out right. I will often talk to boards and hear them say the rules in our bylaws. And remember, whenever we're talking about the rules and restrictions, we're talking about that declaration. That's the document that says, here's what you can do in the community. Then we have the bylaws. Think of the bylaws as the day-to-day procedural rules for your community. This is who's going to be the board of directors. You have 5 directors, 10 directors, 4, 3, whatever it is. This is when they're elected. This is how they're elected. This is how they're removed. They must meet this many times a year. These are their powers. This is how the members meet. They must have a meeting once a year or once a quarter or whatever it is. Here's quorum for how many people need to show up so you can do business. That's what the bylaws do. Now, the bylaws are still very important, but keep in mind, the bylaws are not the document to set up your rules. Now, in South Carolina, based on that new statute that came out several years ago, bylaws are recorded. In North Carolina, the bylaws sometimes are recorded. They're not always recorded, and it's not required. So they can be changed without going through the same process as a declaration. Because again, they're intended to just be the rules on, here's how elections happen, here's when meetings happen, here are the powers and restrictions of the board of directors, they can hire a management company, so on and so forth. It's not designed to say you can't plant your flowers here, or you can't do this. That's what your declaration is for. And so the hierarchy, again, declaration, articles of incorporation, bylaws, because every once in a while, I'll see where a developer did shove some rules in the bylaws. If they conflict with the declaration controls every time. But it is important to know your bylaws, especially as a board, because this is what will tell you, hey, how many times do I have to meet? We got a director who's not doing anything. What are the rules in our community for removing them? I've seen a million different ways that's done in the different bylaws. So you do want to know how those things work. So how do you get on the board? I'm going to fly past these next couple ones because I'm sure you know these things. But two main ways. First is you're elected. There's an election that happens, so must be a called election. I mean, a called meeting. Business must occur, and business can only occur if a quorum is held at that meeting. So if you're not hitting quorum, you can't hold business. And you could be elected by the community. Majority vote, unless you have something in your declaration that has some other more complicated scheme, is typically majority at that meeting with quorum wins. Or you could be appointed to the board. Now, typically when you're appointed, unless there's language in your bylaws that says otherwise, you will serve until the end of that vacancy's term. So you have some boards where everybody serves. So election happens this year, everybody serves for 2 years. You have some where they're a staggered term. One person serves for 3 years, 2 years this person, 1 year, then it rotates in 3-year cycles. But whatever, so it's important for board members, you should try and keep your seats understanding a lineage of who's in what seat. Because if a seat becomes vacant, you want to know, we're going to appoint Mike to take this seat over. We want to be able to tell Mike, hey, Mike, you actually serving this for 2 years, or the election comes up in 5 months. You got to rerun if you want to stay on the position, because that might affect how someone wants to serve. Like, hey, I'll help out for now, but I don't want to be here long term, or vice versa. So those are the main 2 ways. Now, I will say this also, contrary to popular belief, if the board does fall short, so let's say you have a 5-person board and someone resigns or moves away or otherwise isn't on the board anymore, you are not required to fill that seat before the election. Now, when the election comes up, you obviously hold an election for it, but you're not required. I will often hear some rabble-rousers in the communities that just want to cause a problem. A vacancy happens and then they go, I want to get appointed to the seat, and the board declines because they know it's going to be nothing but trouble adding this person. They are not required to fill that spot unless your declaration says, I mean, your bylaw says it. If your bylaw says any vacancy you must fill within some amount of time, which so far I haven't seen. I've never seen that before. If you don't see any language like that, you're not required to fill it. Now, obviously, you have to keep the HOA going. So if you end up with 1 board member, you might want to start talking about, I need to get some people on here with me. But otherwise, you're not required. Again, how long do you serve? And unfortunately, a lot of my answers are going to be, you got to look at your bylaws, because the bylaws will say what the terms are. Some staggered terms, some serve a certain amount of time. And you may have some communities, the mixed communities, where there's townhomes, condos, and single family homes, and you might have bylaws to say there must be 1 person from this section, 1 person from this section, and so on and so forth. The key is make sure you're following your bylaws. I have run into communities recently, especially the mixed communities, where you may have a master association and sub associations that kind of all work together. And I've been discovering that they've been running it completely wrong. What that means is when problems pop up, you don't know how to solve them. So the first thing you need to do is get back onto what your documents say you're supposed to be doing, or again, change the documents based on the procedure, because you have to follow the documents. Because if you don't, when problems happen, then you end up in fights where everybody's fighting each other. What do we do? And you can't refer to the documents that you've been ignoring. So either follow them or change them. But the biggest thing to do is, as a director, you want to make sure, and typically it's usually Article 3 and Article 4 of your bylaws that will deal with the board of directors. You want to make sure, don't memorize it. And I'm not suggesting you have to memorize it, but you want to have some familiarity with it. How often do we have to have meetings? What are our terms? You serve this long, you serve this long, you serve this long. How are we going to select this position? If we got to remove someone, what are the rules for that? You want to make sure everyone knows you're in charge, you know what's going on.
Before we move on, Ken, we have a couple of questions about how to get on the board and who can be on the board.
Sure.
So the first one, this was actually asked about 20 minutes ago, but it didn't quite fit into our conversation. So
Okay.
it does now. Can a fiduciary of an estate be a board member? It's just a matter of time before the house is deeded to her from the estate, but she was elected to the board before that happened. If not, can she just be suspended until the deed is actually in her name and then resume her position on the board?
That is a very good question. It depends 100% on your bylaws. So go to your Article 3, Article 4, or somewhere around there where it talks about board of directors. You should see a paragraph that says qualifications. Usually I see it with number, term, qualifications, somewhere in there. Look for what the qualifications for your board are. If she meets the qualifications, or as commonly, I would say most bylaws don't have qualifications. That means literally everybody in the world can serve. Technically, if your declaration has, or your bylaws have no qualifications, I could serve on all your boards of directors. And I've actually seen that plenty of times. So in that case, she could absolutely serve. Now, if it's a situation where it says only the record title owner can serve, then she would need to be off the board until the record. And so what you would do is she would, yes, suspend her off the board or make her an unofficial board member or whatever. And from there, you would have to appoint her or reappoint her whenever she qualified under whatever your bylaws say. However, I will say this, anyone that is not a voting member of the board of directors should not participate in any executive sessions. And that's the part of your board meeting where you go in and talk about violations and fines and things like that. Only actual board members who can actually vote should be part of those meetings. So even if she has the best interest in mind, you want to work with her, once she's reappointed, she can come. Otherwise, she would need to be excused at that point of meetings until that happens.
Thank you. Okay, so this also probably just depends on the documents, but can a board appoint a replacement even if there are no provisions in the bylaws that appointment is allowed?
Yes, because typically that would then go back to, and I apologize, I did not memorize chapter 55A or title 33, but there are provisions in those that the Title 55A or Chapter 55A and Title 33 are the provisions that really back up the bylaws and board of directors. And there are provisions in there that allow, they're gap fillers, we call them, where bylaws forgot something, you can go there and catch it. But yes, if it doesn't have a provision for appointing a member, the law actually has a provision for it. So you would be able to do it.
Okay, and along the same lines, if the articles of incorporation state that elections of board members will be done per the bylaws, and there have never been elections so far, what's the recourse there?
Okay, that's a very interesting question. Articles of incorporation said, hey, there's going to be elections, need to happen based on the bylaws. You got to follow the bylaws. But I think what I'm understanding the question to mean is, previously, whoever's on the board or whoever's running things has essentially not held elections. I will tell you, that is actually one of my red flags. Whenever I've seen that in communities, typically I've seen problems pop up. Because I'll be honest with you folks, let's be honest, this is a very thankless job, but somebody's got to do it, right? It's not exactly like people throw you a parade when you get elected to the board of directors. People are more likely to scream at you for stuff that's going on. So whenever people want to stay on the board of directors for extended periods of times, that's a little scary a lot of times. And there have been a couple of times where we've discovered theft or kickbacks and other bad things that were happening whenever we've seen that. So essentially, whenever that happens, I actually direct the property manager from Cedar to tell that board, we need to have an election. Now they can run again, they can absolutely run, but we need to have an election ASAP because you need to get it into the record. Now I will say this, a little scary thing, folks, and this actually applies to South Carolina too. Tennessee, I'm sure it's there, but I can't confirm. In North Carolina and South Carolina, HOAs are actually regulated in part by the Secretary of State, all nonprofit corporations. So whenever you think of the Enrons of the world and fraud happens with the for-profit corporation, then you got the shareholders, board of directors, or someone overlooking that's going to sue or do whatever they can do to try and get things back in line. HOAs, they're actually observed by the state of North Carolina. And whenever a nonprofit corporation is not operating or doing the things it's not doing, there's always a possibility that the Secretary of State can go get a court order to have a receiver appointed to take over your community. And folks, whenever we've seen it, a receiver is no one other than an attorney or a CPA who basically spends all your money looking over your records and checking over everything. And then they have an election, but by the time things happen, you're broke. Because they will bill you and bill you and bill you and bill you. So I would say it is in your best interest to make sure you're not doing anything where someone might go to the Secretary of State and say, hey, there's problems over here. We need your help dealing with it. Because we've seen it a couple of times and it's very bad. So essentially, two ways this happens. Like I said, I direct the property manager. They need to go have an election. This election has to be scheduled ASAP. Or second, at least in North Carolina. Now, in South Carolina, it will depend completely on whatever your bylaws say. In North Carolina, the 10% of the community can call a special meeting. And for whatever purpose it is, for elections or whatever it is, and if 10% you have 100 homes, 10 people sign a petition, you're going to have a special meeting. Now, you still have to meet quorum and all those requirements to hold the election, but there are ways to get around or ways to fix it. But yes, an election absolutely must be held.
Okay, and here come two questions we see as managers and attorneys every day. And they're similar to each other. With board terms, the end of the term, nobody signs up for the ballot. What if you can't get anyone to serve on the board and you're in the same seat? What can we do? These are things we see all the time. We don't have enough participation. Can you give a little direction on what can be done at that point?
That's a good question. I wish I knew the answer to it. All I can say is you got to find a way to get people to do it. I'll be honest with you, the scare tactic I just gave you about the receivership, that's what I tell communities. I've had a couple of situations with that. I had one situation where I was in the middle of a lawsuit with defending an HOA, and then I found out the board was gone. I had no board, and I'm like, technically have no client to direct me. And I went to the property manager, was like, you go find me a board member now. And I mean, like, as in yesterday, because I got problems here. Ultimately, we got to encourage people to be, even if it's, hey, order pizza at your meals, and I mean, at your meetings, and only have a meeting once a month or once a year or whatever it is. We got to get people on the board. And I often tell the scare tactic story. Feel free to go back to people and tell them what I told you. Receivers get appointed. They are not, you know how the lawyers are, and they are not the cheap of the lawyers. They're the ones who will come and bill you $500-600 an hour, and all they'll do is just, go through all your paperwork and come back, and nothing will get done. But they'll bleed you dry. So that's often what I do. I wish there was some way that I could say there's a way to encourage people to be on the board. It's not an easy position to fill in a lot of places, but it is a necessary job. Sorry, okay. I wish I had a better answer.
I know, us too.
Yeah.
We do have one hand raised, and I've got one more chat question, and then we can move on.
Sure.
Alicia, your question?
Hey, Ken, it's Alicia Anderson.
Hello.
Hi, I was going to email you, but I just took over an association. There are no bylaws, not recorded, and not that any of the boards have. So I know I default to the North Carolina Planned Community Act, but I just didn't know off the top of your head, since there isn't bylaws dictating the number of members and officers, is there a requirement after the termination period of declarate control of how many board members I must at least have when there are no bylaws?
Nope, you just got to have one. First thing I'll tell you to do, and I've run into this several times, we got to create bylaws like yesterday. Let's go ahead.
Yep.
We'll go ahead and create them, and we can do whatever we want to do. But as long as you have one person serving, you're good. Obviously you want more than that. And also for everybody on the call, I recommend odd numbers. I hate whenever I see boards have even numbers 4 and 6 and stuff like that, because what are you doing in case of a tie? Your board should be odd numbers at all times.
All right, thank you, sir.
Yep.
Great.
Let's
And
go and create those.
the last question, I think we sort of touched on this a little bit, but the question is, parents of a homeowner participated in a board election without a proxy letter. Is this permissible at any time? And are they even allowed to attend meetings?
Okay, good question. Technically, as a nonprofit corporation, meetings are public. So technically, someone from a neighborhood down the street could technically come sit in your meeting. They are not really allowed to participate they can just observe. So you do have the right, you do have the legal right to tell people, you need to excuse yourself, and hopefully you never get this far. You can actually call the police and tell this person, and tell them this person needs to be removed. They're in the way. Technically, you could do that to rowdy homeowners too. Homeowners have the right to be there, but they don't have the right to get in the way and you know, cause trouble. And most of us have seen those communities. You got that one person that just wants to be a problem no matter what. You can tell them to leave too. But essentially, they absolutely cannot vote unless they have the right to vote, which only members can vote. So to vote, they would need that proxy form, a proper proxy form. And other than that, they can appear, but they can't participate. I would actually also say, if you pay very close attention to the proxy forms, they give these other persons the right to vote, but they don't give them the right to participate. So they don't get to get up there and ask a whole bunch of questions and make suggestions and think, I think the HOA should be doing this. Well, who cares? This isn't your community.
Thank you.
Okay.
Okay, we do have one more hand raised. I know in the interest of time, we're coming up on 7:30. Miss Eunice, do you want to go ahead and ask your question? We'll get back to the slides.
Yeah, this is in regards to when Attorney Love, you said you hate when it's an even number on the board.
Yes.
In my situation, we are 2 people on the board. The other person has submitted a CCR request. So
That's why that's another reason I hate that, because now you have to, and I actually talk about this a little bit later on. Can we table this just for a second?
yes, yes.
But yes, because that's another concern I've had. I've run into that too many times in the last year. So folks, I'm gonna try and speed up just a little bit to get through some of this mundane stuff, because I think when we get towards the end, when we get some of the juicier stuff. So you're elected. Bylaws will have the duties that you must follow. So I would recommend you look at those. It's pretty universal, but again, I still look at, like, you get to hire managers. There are times that you can take out loans and you can't take out loans, and how you do. I would read them, because while they're pretty universal, there may or may not be differences in yours, and you want to know what it is you can do. I had a board that I'm meeting with Friday, and I was told by their last community or their manager that their last community manager told them, hey, we can remove board members when you see fit. I read the bylaws and it's like, no, you need to vote as a community. There's nothing in here to let you do it without the community. And so I'm gonna meet with them and talk to them about it, but the rule is very clear. So they were advised inappropriately before. You also want to assign officer positions. So the community elects the board. They don't elect officers. You will then, after you have the board, you're the president, you're vice president, you're treasurer, and depending on the size of your board, you may have people who sit in multiple positions. I may be secretary and treasurer, or vice president and secretary. That's permissible. The only 2 positions, really, the president should never do it, and the president should never be the president and the treasurer, because the treasurer will have certain duties where they should be looking at bank statements, seeing how the money is being spent, and the president will have certain powers too. Having one person with both of those positions is just too scary. Every time that I've had to sue a board member and get money back from an HOA, that was one of the things that was going on. They were serving as both the president and the treasurer, and it's very easy to hide information from other board members when you're doing that. So that's the only thing I would say about that, is make sure you never have both of those persons doing that, or a person serving in both of those positions. So let's talk quickly about the duties, and then we'll talk about pitfalls and best practices and so forth. So in this section, we're going to talk about confidentiality, fiduciary duty, enforcement of the rules, management, control, and oversight. So we're going to get to some of these questions we were talking about. So confidentiality. You know, obviously we're not in the military. This is not top secret stuff, but you should treat a lot of what you deal with as a board member as such. There are going to be times where you're going to receive information about homeowners, violations, fines, who's paying, based on both fair housing rules and fair debt collection rules. This is information that should not, under any circumstance, be shared with the community at large. Because the biggest thing to remember is you have very little control over what people do. And if you ever let it slip that John Anderson over in 102 hasn't paid his dues in a year, you never know what the next person is going to go and do. Someone may post a sign on their door or decide to confront them. I've seen situations where this has happened and it gets nasty. So that type of information should stay guarded. Also, your vendor contract should stay guarded, because in most cases, they tell you, and part of the contract is we don't want our contracts out there. And a large part of that is because all of these industries you're dealing with, if you have a pool, the pool vendors, management companies, other the landscape contracts and all that, they're competitive. They're in business, and they don't want you sharing their contract with 200, 300, whatever plus owners that could go and maybe have the relationship with another landscape company that says, here's their contract, you know what they're doing, and you can be more competitive with them or fight their contract or whatever. So you may hear some homeowners go, we want to see the contract for this. That is a board thing. That is not one of the things that the general statutes or the code of laws in South Carolina tell you to give to owners. So contracts should stay with you. There comes a time where your leaders need to talk and you need to be able to discuss things. When you go into executive sessions, those executive sessions should stay with the board. There should be a record kept, but this is not a record that should be given out. So I've had a couple nasty situations where board members decide to start recording each other and sharing it. That shouldn't happen. Now, if board members are doing something inappropriate, the board needs to take steps to deal with that. But you shouldn't be like recording each other and going out to the community and saying, this board member said this board member said that. So at some point, a lot of this information needs to stay with the board. You can't afford to have 200 people micromanaging the board. If anyone's ever served on a committee of 200 people, you know nothing ever gets done. And that's exactly what you would do once you try to get the homeowners involved with everything. But always remember, your first duty is to put the interest of the association first. In every decision you make as a board member, you should always keep in the back of your mind, is this in the best interest of the association? Even if a decision may not necessarily be popular, sometimes people don't know what they essentially need. And there's obviously information you have that they might not have, but you always got to consider what is in the best interest of the association. And like I said, you may be forced to do decisions that you don't like. So I've seen boards, we talked about it earlier. I don't want to enforce this rule. Doesn't matter if you don't want to enforce this rule, you need to. Or you need to not enforce any rule and just say, forget it, and chaos reigns. But ultimately, you must do whatever is in the best interest of the community. If the community says we don't like this rule, fine. Then you take the steps to amend the declaration, get rid of the rule, everybody's happy. But otherwise, it must be followed. And this is where you will see a lot of criticism, because you will see a lot of people who will argue you're self-dealing, or you're doing something to benefit your friends, or you're doing this and not doing that. Staying consistent and making sure you follow what's best for the community is what protects you as a board member. And again, enforcement of these rules. So a major part of your job is to enforce your rules of the association. Associations serve a purpose. You just have to. But again, if you stay fair and consistent, if you are consistent in the rules and you are fair in the rules, no matter what. So I learned a long time ago when I was working customer service, working my way through school, I was always told the hardest thing to ever do is customer service, because no matter what you do, you can never please everybody. There's going to be that one guy that walks into the store that had a bad day, and he's going to be nasty no matter what. If you give him the best service, he's still going to be mad, because that's just how some people are. And the same thing here. You're going to have some homeowners, even if everything's going well, they're going to have something to criticize. That's just all there is to it. But if you do what you got to do and you stay consistent, everybody knows that person is someone you don't bother with, and that's it. A lot of times when I see these people appear, the board comes to me and says, what do we do? And I go, ignore them. Sometimes the worst, back when, and I guess I'm dating myself a little bit. Some of you are older, maybe younger than me. But back when gangster rap first got popular and they started putting those stickers on the CDs and limiting who can buy them, one of the producers out there in California that was producing some of the big acts said, the best thing for us is this bad controversy, because controversy is what sells tickets and sells albums. And then sales went up. So sometimes the worst thing you could do is give those people a platform and deal with them. Now, and we'll talk about this a little bit later too, you still respect everybody and deal with everybody's opinions and what they need to do, but you don't engage with them. Don't take this one person who's fussing about everything and basically elevate them to the position of the board where you're actually having a genuine debate with each other with the community. You deal with it professionally. Hey, we can't talk to you about violations. We're treating everybody the same. You will see the action when it happens, but we can't comment on specific community properties, and leave it at that. If he wants to fuss, he can call Cedar. Cedar knows how to deal with those people. They deal with them all the time. Miss Anderson, who asked the question earlier, could tell you there are some people who are more persistent than others, unfortunately, but you have to be able to manage this community without being micromanaged by somebody else who won't serve on the board. And remember, do not pick and choose which rules to enforce, because once you do that, you're going to have a hard day in court. If you start doing that and someone else comes out and says, well, they allowed them to do this and not me, you're going to run into some problem. Plus, that's an easy way to accidentally discriminate, because you may allow one home to do something and they happen to be a Black male, and then you turn around and don't allow another person to do something and they're an Asian female. You just walk yourself into a potential FHA discrimination lawsuit. And so it's best to stay as consistent as possible so you don't even accidentally discriminate, which happens more often than you think. And you should finally make sure all board members are following the rules. So let's talk about, if you don't mind, ma'am, this is a good time for your question if you're still here, because this is actually, I've run into this problem. I've actually been in a couple lawsuits recently because of this. So your situation, 2 board members, 1 person sent an ARC request. If you don't mind, go ahead and finish up your question if you're still there.
I'm still here. So she sent it, and I know due to conflict of interest, she cannot vote on it.
That is correct.
And I don't want it to be a situation where I vote on it and it makes it look like because she's on the board, I just approved it. I'm trying to figure out how is it if I decide to go to the old president, because she has been here since this neighborhood was actually built.
Okay.
Can I ask her to be my second side?
I think you can appoint a committee. So boards are, again, same thing as any nonprofit corporation. You can actually appoint subcommittees to do certain things. So you can appoint an emergency committee to help you in situations like this. But again, and folks, I know I'm beating the horse. The horse has been dead a month ago and I'm still beating it. As long as you stay as consistent as possible and fair and you follow the rules, then that's all there is to it. So I think what you would want to do, even if you do get a few people to decide it with you, you still want to have a record. So I would probably call a special board meeting, consider it with yourself and whoever appointee you brought with you, and make a note as to why you decided to approve it, why you did not approve it, either or, and cite to the declarations, oh, I couldn't approve this because our declarations say no privacy fences and you asked for a privacy fence. Or I did approve it because the plans look good, this is what has been done before, everything seems to be in order. That will cover you if down the road someone says, oh no, you only approved it because they're a board member. As long as you can justifiably say you would have approved this for everybody else or denied it for everybody else, then you're fine. Does that make sense?
Yes, thank you very much.
Perfect. But that's an important thing, because I've actually had this come up plenty of times where a board member, or a lot of you have ARC committee members where there's an ARC that actually runs separate from the board. I will tell you this, folks, if you have an art committee that is separate from the board needs to be overseeing that art committee as much as possible. That doesn't mean you have to be at every meeting and doing everything with them, but you need to be reviewing the decisions as efficiently as possible and making sure you know what's going on. I had a lawsuit that was a little bit more expensive than I would have liked for the association, and a lot of it stemmed from a homeowner that happened to be in the art committee and went and approved something for himself or got some community, and it was something that, one, would not have been approved, and two, didn't follow any of the processes. And that led to a lawsuit from the neighbor. The neighbor dragged the HOA into it. So the HOA spent thousands of dollars of money they should not have spent because this person was allowed to do this. And I've actually seen this a couple times where board members approved it, or I'll talk to a board when a lawsuit's filed and I go, so when did you put this up? Oh, no, so the last president told me I could do it. Follow your processes. So if you have an art process where it's sent it to Cedar sends it to us, we review it within 2 weeks or whatever it is, we get back to you. That needs to be followed every time, even for board members, especially for board members. Follow the same process. That will keep you out of trouble and keep your bank account from depleting. I've had this far too much in the last couple of years where I'll be told, oh, this is going on. And I go, okay, so what's happening? Well, this former board member approved these 3 people to do it. Would it have been approved for anybody else? No. And where's the ARC document? Oh, they never submit anything. And so those are the worst. They told me orally I could do it, and there's no documentation for it. So make sure that the board follows the rules. You don't give exceptions to people. The process is the same process every time. And finally, the board can never approve a violation of the declarations. So I've seen in many declarations that say no privacy fences. The board can never approve a privacy fence, period. So if you approve a privacy fence, not good, and it's unenforceable. The next board can come right behind them, as long as it hasn't been 6 years, and they could actually violate that person. And if they violate that person, and we'll talk about liability later on, expect that person to try and come back after you. And we could talk about, that's going to be one of our last slides, to talk about liability and protections. Let's see, 7:43. Nicole, Al, am I going directly to 8 o'clock so I can make sure I time myself out?
Yeah, I think you're okay. We do have a couple of hands raised. If we go a couple minutes long, that's fine.
Oh, and that's fine. I just want to make, I know I think you had a video or something. I want to make sure I didn't take time away from that.
Yeah, no, we'll do a raffle drawing at the end. So anybody who sticks around that long can
perfect. Well,
be a part of that. But we do have some hands raised. So
this is a good time. Let's go ahead and see what we can take right now.
Okay, Miss Patrice, I think you're first.
Okay, so my question is this: in our community, had a couple of incidents where people are bringing commercial vehicles into the community, and I actually got a call from a homeowner that was very aggressive about it and telling me that when their guest comes, that they're going to be allowed to park in the parking lot because they called the police was called, and the police department said to them that it was fine because it was in the parking lot. But yet in our CCRs, it specifically states that there's no commercial vehicles allowed in the community. How do we handle such a situation? Because it's occurring a little bit too frequently.
Good question. Now, when you say parking lot, are you talking about like a common area parking lot?
The common area parking lot.
Okay, and that parking lot is private. The HOA maintains, the city does not maintain it, right? So let me say this, folks, and again, I'm gonna be careful. I am not anti-police. Police are a necessary part of this society. If we got rid of police, the country falls apart. Let's just be honest about that. Now, police are great for enforcing criminal laws. The police do not know civil laws. And I don't know how many times I hear people and police officers will make recommendations or suggestions. They don't know what they're talking about. It's not their expertise. I'm not going to go and arrest somebody tomorrow because I don't know what I'm doing. That being said, the officers are dead wrong. If it is your common area, you decide what is and is not parked there. So in your situation, if you know who the offenders are, you can send them a notice and call them a hearing and violate them. also, if it is the common area, or for those of you, and only for those of you who have private roads and the parking lots and all that are private, you can actually tow from those areas. What I would strongly recommend is that you need to talk to whoever your city is, because every city will have different ordinances on how towing works. So the city of Charlotte has rules, and even in your private parking lot, you need to have a sign posted at the entrance that says unauthorized vehicles will be towed. So if you get that sign posted, I would recommend whenever you see one of those vehicles that are illegally towed, you put a notice sticker on it that says call Cedar, or move the thing, because if we see it again, it's going to be parked, and take a picture of it so you have evidence that it was posted there from, the owner rips it off and tow the vehicle.
Thank you.
For private parking lots and private road. Do not do this on public roads. That's for the police to deal with.
Okay.
But yep, and I guarantee they're going to say the police told me this, and then tell them subpoena the police to the court if you sue, and see how much fun they have with that.
All right, and we
All
have
right.
a question from Tremaine.
Hello.
Yes, ma'am.
My question, I came in a little late, so I'm not sure if you guys talked about this, but when I first joined the board, I was the additional person, and I was just trying to learn more about the board, and all the board members above me quit. So it left me on the board by myself. So I had no knowledge of what a board was or even what to do. So I ended up getting a new board, and half of them people quit too. So for like the last 3 years, it has been like me struggling to find people to get on the board, and I have become like the appointed president by default.
Sure.
So recently we just got a new board. We finally got a full board for the first time since I've been on the board. And the new members who have joined the board are against everything that I'm doing. Even to the point to where we couldn't financially afford to open our pool. So I let the neighborhood know, like, if we didn't get our collections up because we're like 43% delinquent, then we wouldn't be able to have a pool this season. And we had new board members join the board, and they voted to open the pool against what me and Cedar Management property manager told us. So now they opened the pool, and it was only open for 2 weeks, and the pool is closed, and we're broke. So we're in a financial situation because the new board just thought that I was being a jerk by not opening the pool, not even considering the delinquencies. So like, what do you do as far as that? Because right now we're like in a situation to where we have to pull out of our reserve fund just to keep the neighborhood running, and we're going to end up running out of money in the next couple of months. We did an emergency due increase, 5% due increase. And right now we're looking at a special assessment, but if the new board members wouldn't have voted to open the pool against what we've been telling them, then I feel like we wouldn't be in this financial situation. So do you have any suggestions on how to deal with this kind of situation? Because it's like the board is fighting against each other. And I've been doing it, like I say, by myself for the most part for the last 3 years. And I've been trying to get out of the position, and nobody wants to step into the position, but then everybody wants to tell you how to do the position.
Sure. Yep, that sounds common. But unfortunately, we already talked about it, so I'm not going to talk about it again.
Oh.
No, I'm not going to do it. No, that's a good question. If you will table that just for a second, I promise you I will cover that, because I'm glad that's a good example to talk about when we get a little bit later on.
Okay, thank you.
And I promise you we're going to talk about that. So folks, management control, and folks, I think we're coming close on time. Some of these slides I'm going to go through quickly. Nicole and Allison, I'm going to share this with you, this PowerPoint. Feel free to share this PowerPoint with whatever property manager wants to give it out to their board and the board wants to have it. However, folks, I will say this, different attorneys have different opinions. So if you have your own attorney and you're happy with your attorney, follow whatever your attorney is saying. So I may disagree with an attorney, or I tell you, I take a very conservative stance on a lot of positions. I serve on nonprofit boards, and I'm very conservative how I deal with voting and some of these other issues. And some other attorneys may not be as conservative, or maybe even be more, but make sure you are in line with whatever your attorney is if you're happy with your attorney. But I'm going to share this, so some of these slides that we kind of run through a little bit, you could go back and review. But remember, you have to run the community. So I'm gonna kind of scroll through this a little bit. Also keep in mind, you have the responsibility to oversee all your agents and vendors. If vendors or agents are not doing their job, you need to hold them to the fire or get rid of them. Do not hire someone. And I'll be honest with you folks, I guess it sounds like it's a self-dealing pitch because I work with Cedar a lot. I like Cedar. Is any organization perfect in the world? No, because I certainly am not, but I like Cedar. And there are a lot, I think you've heard a couple today, my old management company. I've worked with a couple other management companies that I go, ugh, and I've sued some management companies. There's some that are out there that are flat out crooks, but you still work with your property manager. Make sure you're overseeing the financials. As I heard our last question, she was trying to, and she got stopped by her own board. But if you have vendors cutting your grass, make sure you're watching those. The biggest thing I will tell you, though, is make sure you watch out for the lowest bidder. A lot of people, especially with landscaping, go and find the lowest bidder, and then they find out why they're the lowest bidder. So I would say when you hire someone, make sure you get references, make sure you take a look at what they're doing. The company that I end up having to fight in court in most are the roofers. So for those of you who got townhomes and condos that you have to do roofing for, vet them. Make sure you go and see their projects. If they come out and you say, I need to see 6 or 7 more of your projects, go drive around and watch them. Talk to those boards and say, how are you happy? Because I've had to sue or fight so many of them because they go and put junk up on your roof and then it's leaking a year later. So make sure you are overseeing that process. So best practices, and this is where we could get to her question and some of the other questions that were out there. I recommend every HOA board has some kind of ethics pledge, and it's just a statement that basically reminds you, and I believe Cedar has some samples, and there are different samples out there. It doesn't have to be any particular format, but it's just a reminder to folks that you have to keep the fiduciary duty of the association first. You should not engage any conflicts of interest. You need to disclose if you are engaged with them. Make sure that every board member should sign it. Frankly, I'm concerned whenever I hear board members refusing to, because it's not designed to be a, let's go sue this guy. It's designed to be a, hey, this is the rules we're all working under. Let's work together. And it's a good reminder. Like I said, I serve on the North Carolina Association, I can't remember all the initials, the Youth Soccer Association, and I serve on the board of a charter school. And yeah, I've signed an ethics statement for both of them. And the key is I make sure that I do what's in the best interest of those associations, not myself. Also, make sure you know to keep a work-life balance. So when I hear the last question that was basically, I'm doing it by myself, even when you do that, do your best to make sure you take care of yourself. Most of us are working. We've certainly got family and friends and social lives. You got to keep those going. You cannot make this an all-consuming task. Whenever I run to those boards that are basically, I'm getting emails from them at 2 o'clock in the morning and 4 o'clock in the morning, it's like, okay, this is going to drive you nuts after a while. Make sure you keep yourself in a good balance. Now let's talk about conflicts of interest and then later we'll talk about liability. Yes.
And can I ask a quick question?
Sure.
Can an individual board member, can we be sued individually?
Well, I'm going to talk about that later on. That's a good question.
Okay.
That's a slide I'm going to get to when I ask the last question. So I'll answer both of your questions with that. Let's talk about that. You know what? Let's talk about conflicts of interest. I'm going to jump to that and come back whatever I need to come back to. So conflicts of interest, whenever the most serious problems happen here. So whenever 9 times out of 10, whenever I had to sue a board member or we've had to call the cops on a board member, this is it. And so the biggest times that we see this is when people forget their fiduciary duty and they decide to take care of numero uno at the expense of everyone else. So remember, you can't benefit yourself at the detriment of the community. So when does this happen? 5 main situations that we see this. One is when directors enforce rules on others, but not themselves or their friends. So their friends get away with stuff. They put up their own fences and I got chicken wire fence up with barbed wire on top of it. It's not allowed, but I decided to do it and I can get away with it, but I won't approve anybody else to do it. bad day, you're getting sued. And there are some law firms out there that specialize in suing HOAs that would love to see that. Selecting vendors. We've seen it many a time, there are suspicions, and it actually turned out to be true several times, where there are board members that have relationships or no vendors, and they will go out and a vendor will say, hire us and we'll make sure we kick back 5% of our profit to you every year or whatever it is. Whenever that happens, big no-nos. Never do that. If a vendor offers you a kickback for their business, they are basically telling you, I'm going to give you poor service, but you're going to keep giving me the job because I'm going to make sure I put some money in your pocket. And if that happens, and I will tell you this, spoiler alert, you can maybe do some jail time for that. So make sure you are never involved with that. Or when a director has a relative or friend will serve as a vendor, this is a problem too. So now this can be dealt with. I'm on the board, and let's say my uncle runs a landscaping company. It doesn't mean my uncle can't bid on it. It just means I have to take certain steps. I need to disclose that that's my uncle that owns the business, and I need to recuse myself from the vote. So I need to make sure I'm not voting in that. But if I don't, again, big problems can happen. Or the director will receive a benefit, even if it's not harmful to the community. So let's say it's a vendor that does a very good job. I have an HOA that's up in Greensboro, North Carolina. They said the landscaping company does a great job, but around Christmas time, the landscaping company offered the board like a little bit of cash. Showed up to the board and said, here's cash. That's another big red flag because cash can't be tracked, and that's why it was done that way. And I told the board, you cannot keep that money. Now, if you get the money and you put it into the bank account and hold a raffle or put it up for grabs for homeowners or bake cookies with the money and give it out to homeowners, fine. But if you take it, that's going to be a big no-no. And I did advise them, do not take this money. If it was a pure gift and no one's being harmed by it, bad day. No gifts from vendors unless it's something they give to everybody. And 5, plain theft. We've seen theft too many times. When board members find a way to hide everything from other people, theft happens. So what do? Fiduciary duty. If you do run into a situation, and this is part of what the ethics statement says, disclose it. When I served on the board of that charter school, I coached the soccer team, and we were building a soccer field. I recused myself from every single vote on the soccer team. I didn't personally benefit. It wasn't my team. So I never participated in any vote. Whenever we had to put money into doing something, getting an inspection, I recused myself from the discussion and the vote. That's the best way to keep yourself clean from it. Disclose, I'm the soccer coach. And then I can't vote on this. And so in the records, it will show that I recused myself and the other board members voted yes, no, or whatever. Always remember, is the benefit you're receiving for the entire community? If the benefit does not, the community does not benefit, you shouldn't benefit. And refrain from any activity that even the appearance impropriety. I've had plenty of times where it looked like a board member was doing something wrong, and then when we looked at it, we're like, oh, everything is fine, but just the appearance of impropriety. So bear with me 1 second, and we'll go back. But let's talk about this, because we got 2 questions that come here. So the answer to the last question, which piggybacks off the question before that, is no. HOA directors cannot be directly sued in the vast majority of situations. So if you make a decision and it was a bad decision, if you run the community and people just disagree with your decisions, you cannot be sued. You are not personally liable. Now, let me correct that a little bit, because the very first question that people ask lawyers is, can I be sued or can I sue this person? The answer is always yes. The real question is, can I sue and when? And in this case, the answer is no. So if a board member gets sued, and I've had to deal with this a million times, well, not a million per se, it's a little hyperbolic, but I've dealt with it plenty of times. And I've had board members get sued, and I've showed up to court and I've gotten it dismissed, usually in small claims court. So as it's a corporation, we all know about the corporate shield. Directors cannot be sued. You have to sue the HOA. Now, however, and then the HOA has a duty to indemnify directors for when they're acting in their roles. The exception to this is whenever board members are acting in a criminal manner or in a manner that is so wildly outside of their duties and the benefit of the association, that's when you can get sued. So like I told you before, taking kickbacks, not only can you get sued, you can go to jail for that. Stealing money. The HOA is not going to indemnify you for stealing money. So in those situations, can you be sued? Yes. But in most other cases, and going back to the next to last question, and I do apologize for this answer, if the board members decide we are going to open up the pool, even though we know it's going to break us, 9 times out of 10, they cannot be personally liable for that unless they were grossly reckless in that decision. So I would recommend to you to speak to your community's attorney. If you don't have one, obviously have your property manager set you up with one that you should have on regular communication with. You will want to make sure you can communicate and say, this is what happened. What do we do about this? Because you're right, that is a huge problem that board members make these decisions. And I get it. The pool is probably, for those communities that have a pool, you know, that's probably the most controversial thing in your neighborhood. If you don't open the pool on time, people lose their mind. They don't know what to do. But if you can't afford it, you can't afford it. And so that's when you have to have hard decisions. And I've had to do that with a couple communities, enlist your attorney to come in and help you come up with communication to the community to say, let's break it down. Because, you know, you send out the budget all the time. Cedar has the vine and everybody can look at it. No one ever looks at it. But you got to break it down to brass tacks, plain and simple English these people can understand and say, look, we're broke. At some point, and to be honest with you, the next concern is at some point, Mecklenburg County or whatever county you're in, I'm sorry, they may come in and actually permanently shut your pool down if it's not, you know, maintained and kept at a certain level. So that's something they need to be aware of. And if they like this pool, it's time to start kicking in a little bit more money. So folks, I skipped a bunch of slides. We're after 8 o'clock. I guess this might be a good time to take some more questions. And again, I'll share the PowerPoint. So anybody who wants to look at it and perhaps ask questions, they can. For my communities, I'm happy to answer any questions anyone has after this. I would say if you have your own attorney and you see something in here, follow up with your attorney to make sure your attorney agrees with the stance that I take. Do not go to your attorney and say, that attorney over there said this. They may disagree with me, and then you decide whether you're happy with your attorney, not happy with your attorney, or whatever you decide to do. But make sure you have all your questions answered one way or the other. But I do think I saw some hands go up.
Thank you, Ken. Yeah, we'll take a couple more questions, excuse me, and then we're going to do the raffle. If we were not able to get to your questions tonight, please do feel free to reach out to your community manager. We can put you in touch with Ken. And as mentioned in the chat, this entire webinar will be available on Cedar's YouTube channel, and these slides will be made available through your community manager. So we'll take 2 more questions. I'm going to do the raffle, and just in the interest of time, we're going to go ahead and sign off for tonight. We really appreciate everybody for joining. Ms. Patrice, you had a question?
Yes, my question is, if we have the homeowners sign an agreement to pool rules and those rules are violated, must they receive a hearing before we can ban them from the pool in the clubhouse?
It depends. So they don't actually have to sign anything. So are you in North Carolina?
Yes, I'm in North Carolina.
Okay. They don't have to sign anything. The board controls all common areas, including the pools. It's probably a good idea to have people sign. The only problem I have with signing documents is the person who doesn't sign will have some kind of argument in court to say that I didn't know the rules because I didn't sign anything. So I would recommend not having people sign anything. Just send them out like through e-blast, put them on the vine, and say these are the pool rules. If they violate the rules, you are unfortunately under the North Carolina General Statutes required to give them a hearing. However, and then your declaration will determine that it will have some language in there that says how long you can suspend their privileges. Some are limited, some aren't limited. So you can suspend them long term, some say only 60 days. However, I would say, depending on if it's an egregious action. So if you have a rule that says you only can bring 4 guests and they bring 5 guests, I would probably say hold the hearing before you suspend them. If you have a situation where someone gets into a fight and brings a weapon and harms someone, I would ban them immediately with the hearing to be held, and the hearing is pretty much a formality, but I would do it that way. But you
What
would
about
have a
giving-
record of the hearing just to cover yourself.
What about giving access to outside people in the community, giving access, their access cards?
I think you make the decision how you feel about that. If it seems that the person is doing it and constantly keeps doing it, then I think what you do is you make an explicit rule that says, once you get caught doing this once, twice, 3 times, or whatever, you will lose access to the pool for a significant amount of time.
Okay,
6 months, a year, whatever it might be.
Bob Shepherd here. I have a quick question, sir, if I may.
Yes, sir.
I know you've covered this routine with lawn care and that routine, but we have a violator in our community who's been doing it basically for 20 years. His yard is obscene, overgrown and everything else. The boards have never enforced it. Do we have any choice now? He's been doing this for over 20 years.
Good question. So let me revise. I'm glad you asked the question. Let me revise something I said earlier a little bit. So statute of limitations is 6 years. However, that is really for what I would call the permanent violations, like building a fence. Like people don't build and take apart fences every week. It's like you build a fence and I hope it stays up for a long time. Or if I do something significant, I turn my front yard into a whole parking lot. So I have no grass and it's just concrete. Those types of things. However, grass, I could go out, cut my grass tomorrow, it could grow back, I cut the next week, so on and so forth. In that case, the statute of limitations would not apply because every time it grows, the statute runs all over again. So I would say, yes, you need to start you can start taking action. Obviously, I would say start with a warning letter and say, this is unacceptable, this needs to get fixed. Now, here's the next thing I would say to piggyback off that. So there are some violations. The yard violations are obviously some of the most common, trash can, things like that. But they're the violations that I can fix for a small period of time and then go right back to being the problem. So my general rule of thumb is when there's a violation, you got to hold the hearing. However, whenever we have a violation, such as like grass cutting, and let's say you go after the guy, he finally relents, cleans up the yard, 3 months go by, and then all of a sudden he's doing it again, I would say you can start fines again as long as you made it clear in the results of hearing letter that we will be observing. And if you go back to the behavior, we will reinstitute fines immediately without another hearing. As long as it's within the nexus of the previous hearing. So if you say, like, let's say it happened 3 years later, I think you have to have another hearing. But if it happens,
this has been more than grass, and he has trees and just junk.
Sure.
And like ivy growing all over the place and leaves, it's just terrible maintenance.
Sure. And I would say you want to be fairly aggressive with that. We've had a couple of those communities and things get out of control very quickly, and the city might come in. And the last thing you want is the city coming in and condemning a property. Because obviously your property values in your community take a big nosedive when you've got like the condemned property in the middle of it. So I would say go ahead and start taking aggressive notice of it and I would say in a situation like that, be very specific. So grass must be cut to a reasonable height. These trees need to be trimmed, or this trash needs to be pulled out. I would be very specific with your property manager in the letters that go out to him to say all the things that need to be done. So he doesn't go out there, cut the grass and say, okay, I'm good. It needs to be clear, everything he needs to do.
Okay, thank you.
Yes, sir.
All right, I'm unfortunately going to have to cut everybody else off. We will get your questions addressed through your community managers. We are going to go ahead and announce our raffle winners tonight. We did a random draw of those attendees, and the first winner of a $50 Amazon gift card is Elaine Parker. So congratulations, Elaine. Our second winner is Carol Larson. Thank you, Carol, for joining, and congratulations. And the last but not least of a $50 Amazon gift card, Ellen Hines. So thank you everybody for joining. Congratulations to our lucky winners. And again, thanks for the attendance. We really enjoyed this tonight. You can reach out to your community managers for additional information. And as I mentioned before, all of this will be available on our YouTube channel. So thanks. And I hope everybody has a great rest of your evening.
Thanks.